here with my friend
deBeaubien from Shoemaker.
and we are here to talk for episode 4 of HR Office Hours.
Yeah,
and we have
a quick ride. What are we talking about?
Oh my gosh, I'm so excited well, not excited is probably the wrong word.
Yeah.
It's a doozy, right?
Yeah, right.
It is the hot topic right now. And it is the NLRB, the National Labor Relations Board, has come out with a rule, right, Brad? I mean, a rule it's
a decision in a case which, basically makes, creates a rule or creates law under the National Labor Relations Act. But yes, a big decision came out last week, the last week of February. And tell us about it.
Well, what I know about it is that it has to do with severance agreements, possibly some, and within severance agreements, non-disparagement clauses, which are pretty standard in a severance agreement, and confidentiality clauses. There's some questions that I have that I'm sure we'll get to, but if you could tell us a little bit more about just the whole thing, the case, how this affects people. And one question I would like to get to ahead of time, because a lot of people hear the NLRB and you're a private employer, non-unionized, and you think, that's not me.
Yeah, great place to start, because that is a common misperception, right? You hear National Labor Relations Board, you think that has to do with unions. We're a small employer or we're a non-union workforce. This doesn't have anything to do with me, and that's just not the case. The National Labor Relations Act really protects pretty much all private sector employees in various fashions. Yes, there is the union component and collective bargaining. It's a piece of it, but generally protecting concerted activity is sort of the buzzword, which is any worker's right to talk about the terms and conditions of their employment, which is sort of a fundamental, the NLRA and the NLRB as the enforcement board, view those as fundamental rights of employees. Everybody should be able to talk about the terms and conditions of their employment, lest they be, subjected to unfair or harsh working conditions. So just, broad strokes, the NLRA applies to most private sector employees, exceptions being managers and supervisors, right, who really are instrumentalities of the company as opposed to the lower level, workers. Independent contractors are not covered, but most private sector workers are covered by it. So that's the first order of business. And a little side note there, I think that where that often comes up is discussions of pay, right? Because kind of old school thinking is, well, my workers shouldn't be talking about their comp with each other. That's absolutely protected activity under the NLRA, and it is we see it come up from time to time. And again, I'm sort of also of that older mindset, like we don't talk about comp, but it's certainly protected activity, and it can get you into trouble. I mean, just personally, that's kind of how I was raised, is money is an impolite topic. Yeah,
me too. And actually, that could probably be a whole nother episode for us, because pay transparency,
right?
As far as
that's another hot issue.
Another hot topic, right? Is another hot topic. So
let me talk about the case real quick. So we understand that this NLRA and this
what the heck happened
pretty broadly. So there was a group of employees that were let go from a hospital, and they were all presented with severance agreements, which, as you mentioned, contain very standard non-disparagement and confidentiality provisions, right? Requiring them to keep quiet about their employment and the terms of the severance agreement they were asked to sign, and then to not disparage the company going forward. And up until this decision, the thinking of a lot of folks has been, look, I can restrain the ability of former employees to disparage the company because they don't work for me anymore, right? So I'm not imposing on those rights they have as to concerted activity because they don't work for me anymore. So we can have a non-disparagement that it's been generally accepted to include those in severance agreements, not in employment agreements, but when somebody's exiting the company, yeah, we can restrain that. And what this NLRB decision says is no, we can't do that. So because both the confidentiality and the non-disparagement, have chilling effects on the ability of employees or these former employees to communicate and talk about the terms and conditions of their employment, including the severance. So that's kind of the big news. And it's it really, I think probably calls into question 90% or more of the form of severance agreements that many employers are using today.
Yeah, I mean, what I was reading is that the concern is that these provisions would be overly broad. But that's really hard. I mean, to me, when I'm looking at a severance agreement, it doesn't seem broad to me. So how do you, what's an employer supposed to do right now? That's my first question.
Yeah.
And my second question is like, okay, is this going to affect any employment agreements, any confidentiality agreements for current employees, barring the severance agreement, right? Is it going to affect other agreements?
Right. So I think we're still in the inflection point where everybody's kind of trying to figure out, well, what's the path forward from here look like. There's some, I've read some things that suggest that the NLRB may be putting out some additional guidance, because the opinion in the McLaren decision does leave open a bunch of questions, right? I mean, again, you're correct. The criticism of the verbiage in the agreements at issue was that they were overbroad, but without telling us exactly what would not be overbroad and thus acceptable, right? For instance, would language that just says, has a carve out and says, notwithstanding these confidentiality non-disparagements, we don't intend to impair your Section 7 NLRA rights, right? So if you sort of pay lip service to the NLRA, is that a workaround? I think probably just a naked statement like that doesn't get it done, but we're going to have to sort of work with employers to fashion, language that we think kind of threads the needle that, is where we are based on this decision.
Well, what you just said kind of reminds me of what I feel like is the last time, and there was a lot of hoopla about the NLRB, and that was with social media policies.
Right.
And after that, the NLRB actually kind of said, okay, here's a policy that is a good one, right? You can model your
exactly.
policy.
You get the model or some strong guidance. Because what employers and employment lawyers, we don't like sort of having to just, head off into this gray area and guesswork, because it leaves open the prospect of liability or at least of claims, that sort of try and march through that gray. So we like to have some more specific guidance. And I think we've talked about that in another episode about when we don't have clarity, it's just not super helpful for anybody.
Right. So, and I mean, I hope that they do come out with something, right? Because this board will be here for a little while. So, employers that have recently executed a severance agreement, will it be passed? Is it possible that past severance agreements are going to be scrutinized?
Yeah, so the opinion doesn't address that. There is a 6-month statute of limitations under, I think it's Section 10B of the NLRA, which, pursuant to, within 6 months is when you have to file a charge. And so, there's some sense that maybe things, severance agreements entered into within the last 6 months may be, subject to this. And again, the kind of a critical point is the mere offering of an agreement that contains these offensive provisions is, is what the NLRB is saying is actionable, right? So they issued a cease and desist to the employer in this case. I don't know whether there is going to ultimately be any kind of, monetary penalty. But it wasn't that they were trying to enforce it, right? It was just they offered they proposed a severance agreement which contained this language, and the mere suggestion or presentation of the agreement that contained the non-disparagement and confidentiality as written, the simple offering of that was what the NLRB said, no, we can't do that, right? So in other words, we don't want to see it in the agreements.
That's baffling to me, honestly, right? And I'm probably one of the most liberal people I know, because at least in my industry, because it's being perceived as coercion. Right. But any agreement, any severance agreement, any agreement you sign, you get something for what you sign, right? It's an agreement. So there's two sides. So
this is kind of the consenting adults, and we deal with this often, and in the non-compete context too, right? It's like, well, they signed the contract. Why, isn't it a bedrock principle of American law that you can be held responsible for the contracts that you sign? And the answer is, yes, but, right? Yes, but certain things are subject to, you know, a governmental regulation kind of that's over the top of that, right? We restrict non-competes to protecting legitimate business interests, and they have to be reasonable. Similarly, we don't allow employees, because it's a fundamental public good, you know, to look out for the little, you know, the little people, as it were, the working, you know, the rank and file, who don't have a lot of leverage with their employers, right? So there is this regulatory overlay, which I think is a good thing. But it's like, you know, again, where those parameters are is of course the issue.
Right. And, you know, it's lately anymore, it's nowhere in the middle, right, Brad? It's over here, it's over here. Um, so we've discussed, you know, you explain what happened in the decision. So is there some kind of workaround for the short term? What, you know, should employers just immediately look at any severance agreements they have and remove the non-disparagement clauses and confidentiality clauses, or are there
Yeah, I mean, I think there are some clues. We don't have anything definitive, but there are some clues in the opinion. The non-disparagement, you know, the board was critical of the fact that it was not limited to statements about past employment, and that it encompassed non-disparagement, not just of the employer, but of course of its affiliates, affiliated entities, employees, officers, owners, et cetera, et cetera. The NLRB didn't like that. It's like, well, okay, so which leads us to believe, well, perhaps there's room for non-disparagement directed to the entity. But again, I think we're a long way from being able to say with conviction, you know, hey, here's definitively what you know, a verbiage that would pass muster looks like. We're just going to take some time to kind of process that and see what else we get from the board.
So maybe with your labor attorney, look over what the language in those clauses are, and maybe, you know, put if for the non-disparagement, like if it's blatantly untrue, like leave things in like that, right?
Yeah, exactly. There may be a way to sort of to thread the needle. The confidentiality, there was a little more of a pronounced, you know, this is forbidden. Right, they didn't leave a lot of wiggle room on, hey, you've got to keep the terms of the settlement confidential. I mean, that was, they sort of generally tossed it, but yeah, a lot of interesting stuff. What's that?
The terms of the agreement. So because
right, man, which is standard, right? Hey, we don't want everybody going and blabbing about what they got for severance. So
as far as confidentiality, though, would you be able to keep, I mean, I think for me, right, I think it would be reasonable to be able to keep things in like proprietary information.
Yeah, and I think that is a safe, right? Right. Your sort of standard confidentiality of sensitive business information, you know, trade secrets and other, you know, customer list, other things that are not public. But again, the terms of the severance, which sort of go to the terms and conditions of the employment or the exit from employment, falls, according to the board in this recent decision, falls under the umbrella of, well, this is really, you know, terms and conditions that could go to part of that concerted activity, and we want to preserve that.
Okay, because I guess the reason I'm asking is because what I would like employers to not do is have a knee-jerk reaction and
throw the baby out with the bathwater, right?
But yes, exactly, right? Like check with your counsel. You know, get some counsel if you don't have one to go through to check with these things before making a decision based in, oh my God, the NLRB is coming after me.
Right. Yep. I think that's good advice.
Okay. Well, that's what we're here for, right? To bring the whole point of us getting together weekly. We're going to be doing this weekly, everybody. So like and share. And if you have questions, please ask them in the comments, right? Tag Brad and I, we will get back to you for sure. We'd love to have to know your questions. Also, we'd like to know what topics you might like us
Absolutely.
to. So we will see you next time. But Brad, unless you have any last parting words.
I don't. We'll see you next time.
This fun decision. Next time for episode 5 to be announced.
All right.
Maybe we'll get one from one of you. So join us. We hope to see you, and wishing everybody a happy day. Brad.
Bye-bye.